Hello, and welcome to today's podcast. I'm Roger Foisey, a personal injury lawyer at Foisey Associates. And today I'm joined with my colleagues Harpreet Sidhu, Daniel Berman, Ritumi Tank, and Russell Laloshi. We'll be diving into what claimants should expect if they're attending a LAT virtual hearing regarding catastrophic impairment. Whether you've been involved in a motor vehicle accident or you're supporting someone who has, the hearing process can seem very overwhelming. Our goal today is to walk you through the key steps of preparation and what to expect on the day of the hearing. Start with you, Harpreet. Let's talk about strategy.
Thanks, Roger. So one of the first things that we do when we're preparing our legal strategy for a LAT hearing is re-reviewing the client's clinical notes and records. Doing so serves a number of purposes. It allows us to obviously reacquaint ourselves with the entirety of the client's file, both pre and post accident, identify where the client's strengths are when we're talking about physical, cognitive, and psychological function, and ultimately what evidence we really need to bring out at the LAT hearing to be successful. It helps establish which witnesses we want to call, whether that's experts, treating practitioners, or lay witnesses. It could be their partner, their employer, their children. Those are the people that will ultimately be able to support their catastrophic impairment at a hearing. In addition to preparing ourselves behind the process, we're also preparing our clients behind the scenes as well. And that includes a number of different things, namely helping them understand what the process will entail, what the hearing will entail, but also preparing them for their testimony, because we want to ensure that the clients are giving the correct information and they're presenting it in the most beneficial way to their case, focusing on how their physical, cognitive, and psychological impairments ultimately are resulting in them being unable to function on a day-to-day basis.
But Russell, what about a client's involvement in medical evaluations and experts that they have seen? How is it that we prepare for that?
That's actually a very critical aspect of the preparation, and it starts long before the actual hearing itself. Oftentimes, during the hearing, expert evidence will need to be presented from from professionals who have assessed our clients through independent medical evaluations. Being able to be prepared during those evaluations is critical. That's something that not a lot of legal representatives do for their clients. We focus a lot on how a client needs to be prepared during these evaluations in advance of it. What type of information is being evaluated during that assessment? Oftentimes there are competing evaluations, one to address income replacement and another to address catastrophic impairment. In this particular case, we need to make sure that the client knows that they are being evaluated for a catastrophic impairment, what that entails, and what type of evidence needs to be led. We remind them that they need to be honest, that they need to be detailed, and that they need to make sure that the assessor truly understands their level of impairment and how it affects their life.
Daniel, lay witnesses were mentioned earlier by Harpreet when he was discussing strategy. What is it about lay witnesses that our viewers should know?
Different from medical experts or medical evidence, lay witnesses and lay witness evidence and testimony can range from family members, coworkers, friends, and they can provide much more context to the day-to-day functioning of our clients. For example, a coworker may be able to provide some evidence or testimony about our client's inability to go back to work or multiple attempts to return to work. In another example, a family member may be able to give evidence on a client's issues with communication and social functioning. Now, in the LAT context, we find that LAT adjudicators really appreciate and value late witness evidence and late witness testimony because they can provide more than what we call a snapshot in time, which is often what medical reports have or surveillance by insurance companies. Late witness evidence can fill in the gaps that one-time medical assessors or one day of surveillance can't really see.
Ritumi, But truthfully, one thing that's on a client's mind is how are they ever going to get through a LAT hearing? Isn't this a stressful situation? How will I perform? How will I ever get through the day? I've always in pain. I'm always unable to actually do things the way I was doing them before. What type of advice would you give them?
Preparation is key. In the weeks leading up to the hearing, we go over the details of the case with the client. We walk them through the hearing, give them tips on how to testify effectively, and go over the questions that they may be asked. A LAT hearing is very fact-based, so it's important that clients give evidence that is clear, concise, and specific about their impairments and how they impact their daily functioning in all areas of life. If possible, we also conduct a mock hearing. This gives clients more practice on how to answer questions that they may be asked by the LAT adjudicator and the opposing side. It also gives them a better idea of what to expect from the process and helps ease their nerves.
Thank you, everyone, for those insights. Now let's talk about the hearing, the day of the hearing itself. And let's start from some of the logistics, things that clients may actually be concerned about. Harpreet, maybe you can start off for us.
Yeah, LAT catastrophic hearings are done by video conference for the most part, which can make things easier in many ways. For one, it allows clients to testify and watch the entire hearing through the comfort of their own home instead of having to attend in person. But we also have some clients that prefer to do so in a different environment because having a quiet and distraction-free location to testify and listen to the hearing is integral. And so we have some clients that might even attend our boardroom to give their testimony and watch the rest of the hearing. Either way, whether the client is testifying from home or doing it in our boardroom, we make sure that they are familiar with the technology that's going to be used so that there are no issues on the day of the hearing itself.
And Russell, what about the structure of the hearing? Maybe you can assist with that.
Yeah, so the general structure of the hearing is it starts off with opening presentation of the case from both sides. That's both our team and the insurer's representative. And then we transition to testimony. And testimony is generally starts off with the individual who has been injured, who will testify first, and then it moves on to other witnesses. It's quite formal, really. And it can be quite nerve-wracking for a lot of people to go through it. But we're always there for our clients, making sure that we ease their nerves and explain to them the process throughout the entire way.
Daniel, what key reminders or considerations do you offer clients before they actually testify?
When discussing the testimony of our clients, we usually instruct them to be honest, clear, and detailed about their injuries and talk about their function and how their injuries have impacted their daily life, their work, their communication, social interactions, and things such as these. We also instruct them to give examples that can illustrate some of these issues. Lastly, we tell clients that if they don't know an answer, not to guess, but to simply say, I don't know.
Thank you, Daniel. So, Rutumi, what can we expect after all testimony, witness evidence has actually gone into the hearing?
Sure. So once the catastrophic determination hearing concludes, which is usually in 7 to 10 days, both parties submit their closing remarks. This is usually a summary of the evidence given during the hearing, as well as important case law that the adjudicator should consider in their decision. With most cases, especially catastrophic determination cases, the LAT adjudicator will take some time to review the evidence that they have before them. Depending on the complexity of the case, a decision may take anywhere from 3 to 6 months or even longer. In the meantime, while all of this is happening, we always make sure to maintain close contact with the client and give them updates about their case and information about any next steps.
Well, that's a terrific overview of what to expect from a LAT virtual hearing on catastrophic impairment. Preparing for these hearings can feel overwhelming, but with the right legal team in place, clients can be confident they're fully prepared. I want to thank our legal team for sharing their insights today and to all of you for watching. Don't hesitate to contact our office with any questions you may have with regards to such topic. We're always here to help. Until next time, stay informed and stay safe.